Yang Arif, may it pleases the court. My name is Siti Nurhaja binti Muhammad Mani, appearing as the defense counsel on behalf of Mr. Hakim, our client. Yang Arif, my plea in mitigation today will be focusing on the defense by addressing the relevant provision on the sentencing guidelines, and then I will deal with Mr. Hakim's personal mitigating circumstances. The aim of my plea in mitigation today, Yang Arif, is to pray before the court for the relief of our client. And now, I propose to take 10 minutes of the court time to present my submission before the court. If there is no other preliminary question from the bench, may I start my submission, Yang Arif? Much obliged. Yang Arif, I'm looking firstly at the facts of this case as well as the personal circumstances of Mr. Hakim. At time of arrest on 5th April 2020, Mr. Hakim, our client, was found near a fishing pond at kawasan Kolam Changrun, Kubang Pasu, Kedah. He was on a motorcycle type Honda EX5 with a plate number KAD 2668, carrying fishing rods. I seek to persuade Yang Arif that although Mr. Hakim's offence falls within the Regulation 3 Subsection 1 of Prevention and Control of Infectious Disease Measures within Infected Local Areas No. 2 Regulations 2020, it very much falls in the lowest end of the applicable range. Yang Arif, without wishing to detract at all from the seriousness of the offence that was done during MCO, Movement Control Order, Mr. Hakim does not wish to justify his actions, I stress, in any way. Looking both at the facts of the case as well as the applicable sentencing guideline, Mr. Hakim's offence falls under Regulation 11 Subsection 1 for contravening Regulation 3 Subsection 1 on conviction. Mr. Hakim, our client, can be liable to a fine not exceeding 1,000 ringgit or to an imprisonment for a term not exceeding 6 months or to both. Yang Arif, while this offence is clearly in a specified offence under Regulation 3 Subsection 1 of the said regulations, by moving from one place to another place within an infected local area, provided under Regulation 3 Subsection 2, it is some exception that this is one of the events on exceptional circumstances. Indeed, Mr. Hakim's act of fishing was done in order to place food on table for the family. It is so, as he was unable to go out to work in order to earn and feed his respective families. Yang Arif, in considering the aggravating factors of this case, I give the significant mitigating factors to be taken into consideration. Yang Arif, here, Mr. Hakim's genuinely remorse for what he has done. I do ask that Yang Arif to take this very genuine remorse into consideration when sentencing Mr. Hakim. In Raja Izzuddin Shah vs. PP, apart from pleading drunkenness, the accused also showed that he was repentant and remorseful for his act. Accordingly, Mr. Hakim also accepts the prosecution's account of what happened during the event. But it has been a month since he was unemployed. Therefore, he had no fixed abode and he was simply not in a very good place. Yang Arif, it is accepted that there are concerns with Mr. Hakim's long antecedent history. However, the circumstances in which those offences were committed are very different from the circumstances as of now. With regard to the offence of self-administration of drug, under Section 15 of the Dangerous Drugs Act 1952, committed by Mr. Hakim, he admitted to them against a background of substance misuse and that he has very much changed as of now. Yang Arif, these mitigating factors clearly points Mr. Hakim to a sentence at the lower end of the applicable brackets. Standing next and briefly, Yang Arif, at the personal circumstances of Mr. Hakim. Mr. Hakim, Yang Arif, is now only at the age of 21 years old, and when he was arrested, he was unemployed and had no fixed abode. It would be appropriate for Yang Arif to be mindful of other alternative sentencing that is available in our penal system justice. In Tukiran bin Taib vs. PP, The court opined that first offenders who are between 17 and 21 years old should not be imprisoned, but should alternate to other punishment for their benefit and in the long run to the community at large. Young Arif, Mr. Hakim also had unfortunate difficult childhood. He lost his father at the age of 11, and as the eldest son in the family, he has to look after his three sisters and a brother. Mr. Hakim since then has been the sole breadwinner of the family. Even though he used to work as the assistant manager at a supermarket, however, he just recently becomes unemployed after the store ceased to operate in March 2020. His lack of employment and education has caused him to struggle to reintegrate back into society, and he, at that time before the arrest of this offence, quite a limited and homeless outlook of life. Young Arif, Mr. Hakim says difficulties with substance misuse is very much of the past. Since the time of the arrest of this offence, he has actively made changes to his lifestyle. Even though Mr. Hakim has a long history with substance misuse, there is a real risk that he may relapse the offence. But Mr. Hakim said he can now identify new coping mechanisms to cope with this and avoid any such relapse. Young Arif, Mr. Hakim has now been free from drugs for more than 24 months, and according to him, he claims that this has been the longest period of sobriety, and this has also been endorsed by the superior that he has been working with, and therefore it is credible. In fact, 3 days before Mr. Hakim was arrested, he just got an offer to become a manager at Tesco starting of May 2020. Young Arif, while custodial sentence is the starting point for this offence, putting Mr. Hakim into prison would have a disastrous effect and would remove him from the position of stability which he has managed to achieve over the recent months, and in fact, it may also negatively impact his motivation to avoid reoffending further well. Young Arif, I would also like to ask the court to take into account that whilst Mr. Hakim was brought to the court, he decided to acknowledge his guilt, and he did so before a necessity of full trial. A plea of guilty is a strong mitigating factor as it saves time and cost. In South Soo Kim vs. PP, the federal court considered the accused guilty plea even though the offences for attempt to murder and for unlawful possession of firearms and ammunition were serious offences. As such, I invite the court to give credit to these guilty plea amounts that a court deems appropriate. Young Arif, in light of mitigation that have put forward, as well as the impact of fine and prison on Mr. Hakim's life, I would ask Young Arif to consider lenient punishments to Mr. Hakim, which is to lower the amount of fine or a binding over compulsory attendance order under Offenders Compulsory Attendance Act 1954, Act 461. This could be clustered as non-custodial options of sentencing, which is available in our system of administration of criminal justice. This Young Arif would not only provide a proportion and an appropriate punishments for Mr. Hakim, it will also allow him to put food on the table for his family instead of paying a big amount of fine, cost 1,000 ringgit that could last 1 to 2 months to feed the whole family. Young Arif, that concludes the end of my submission, unless I could be of any further assistance. Young Arif, that concludes the end of my submission, unless I could be of any further assistance. May I return to my seat, Young Arif? Much obliged.